afternoon, everyone. This is Kathy Purdy, Marketing Supervisor at Schoeneck King. I'd like to welcome you to the 24th week in a row of coronavirus updates. Just two quick housekeeping items before we get started. Please enter your questions in the Q&A box located at the bottom of your screen. And if you would take a moment to complete the survey once the webinar has completed, we would appreciate that. So to start up today's program, I'm going to turn it over to Pete Jones.
Thank you, Kathy. Good afternoon, everyone. Brief overview of our agenda for this afternoon. We're going to talk about reopening, the latest updates, gyms, bowling alleys, the governor's most recent announcements and guidance. We're also going to talk a little bit about occupancy limits. That appears to be a very popular topic. So Katie Anderson's going to give us a little update on that. We're going to summarize where we are in the litigation front. That's a recurrent topic that has been of interest to people. We're going to go back and summarize where we are with the PPP program. Jeff Shear is going to give us a little view of that. And then we're going to talk about the school reopening, an update on that, because that is, of course, of interest not only to folks who are involved with schools, but also to people who've got kids in schools, and frankly to employers and businesses everywhere because of the interconnection between schools and people's ability to work, or at least ability to work in person. So let's start today with Sam Burgess on reopening update part 1.
Thanks, Pete. So like Pete said, I'm going to touch on briefly the new guidance that's come out about gyms, bowling alleys in the last few days. So late last week, Governor Cuomo said bowling alleys could open as of Monday, yesterday, and that the guidance for gyms would be issued yesterday as well. So the gyms is more complex and has more details in it. So I'm just going to run through that first, and then we'll touch on the bowling alleys as well. So for gyms and fitness centers, it's effective August 24th. But there's also this provision that the chief executives of the county or the New York City mayor can delay the opening date till September 2nd at the latest. Also, those same chief executives can delay or opt out of in-person indoor classes until a later date. That hasn't been specified what that later date may be, but they have the option to do that as well. And now for this gym guidance, it applies to, a standalone fitness center, a hotel fitness center, one in a residential building, an office building, one in a college or university. So it's going to apply, pretty much to every fitness center that's out there. So we've talked about a lot of the reopening guidelines for the past, several months, and most of those are still the same. We have to comply with those same requirements, coming up with our plan, prohibiting the use of small areas, social distancing, post signage, limit the congregation of individuals in certain places. Have plans set up for proper hygiene of hand sanitation, cleaning, disinfection, and doing your screening and testing. Also, what comes into play with this is, just like the other industries, when there's any overlap in specific guidance, that other specific guidance for the industry has to apply. So if there's a pool, if there's a retail store, a restaurant or snack bar, office-based activities, and then if there's sports and recreation there as well, you have to follow those guidelines that have been put out. Okay, then if we get into the specific gym and fitness center guidance, the physical distancing notion is it's 33% of the maximum occupancy, including employees, can be there at any one time. Everyone has to wear a face covering at all times. And in this guidance, there's been a differentiation. An acceptable face covering does not include a bandana or a gaiter. So that's the first time I've seen that, at least, to come out. Also, each individual that comes to the gym or fitness center must complete the health screening, the same questions we've been asking our employees this whole time. And a log has to be kept of that information for 28 days. And they have to sign in with their name, address, and phone number for contact tracing purposes. 6 feet of distance is still a requirement, and that's and that should be at all times. There is a carve out if you need a spotter, but if you use a spotter, it should be for a brief period of time, and it also should be discouraged from using free weight equipment to the point that you would need a spotter. So another requirement for the gyms to open and to get moving and to stay open is that within 14 days of reopening, the gym has to coordinate with their local health department for an inspection to make sure that they're following the guidelines, to make sure that they have everything in place they need to. Also for on-site, going back to our size limits, things of that nature. If there's to be indoor classes, you have to use some sort of reservation, whether it's, you call ahead, you sign-in sheet, reservation forms. But the reservation in the class must be limited to the fewer of the number of individuals that can be 6 feet apart, 33% the normal class size, or the social gathering limit for the region, which as of now is 50. So for example, if you have a spin class that has 30 bikes, usually 30 people, the most people that can be in there is 10, because that's 1/3 of the number of the normal class. Again, we're still prohibiting high-risk activities that are outlined in the sports and recreation guidance. That's not changing by the gyms and fitness centers being open. Also, like we've had to do with many other industries, the amenities must be closed, whether it's our whirlpool, water fountain. You can have a spot to fill up your water bottles, but the water fountains can't be open. Communal bathroom or communal showers should be closed. Individual showers can remain open as long as they're clean between each use. And as for that cleaning, it's the same that we've been talking about, cleaning and disinfecting all of our areas. But in this instance, there has to be made sure that the equipment is cleaned between each use. So there's no sharing of equipment, no sharing sets. One person uses the equipment, it has to be wiped down. And to that point, you have to ensure you have enough staff available to make sure the wipe down, cleaning, and disinfection is taking place. So even though you may require the patrons to do it, there has to be a sufficient amount of staff there to do it if necessary. Also, another big one is that locker rooms and bathrooms must be cleaned at least every 2 hours. So that's something new and something big that must be done for the cleaning purposes. And then again, just for the screening and testing, again, like we said, it is employees and it does include all patrons. You'll see that's different from any other guidance we've really had, and it's different from the bowling alley as well. But each patron must sign in, they must certify to their health, and that log must be kept for 28 days. Also, there's some air filtration system requirements. What it comes down to is you have to have a certification and documentation from either a technician, a professional, licensed building engineer regarding your system and its compatibility to the filtration system. And no matter what system you're using, you must have mitigation protocols put in place, some of which have been discussed previously, but outside air, opening windows, increasing the ventilation as much as possible. So that's just a quick overview on gyms. And then just to touch on briefly on bowling alleys. The bowling alleys was thrown into the sports and recreation guidance, and it had its own separate section for a few pieces, which I'll highlight for you briefly. So no more than 50% of the maximum occupancy, including employees. There has to be 6 feet in between parties. So you're going to close adjacent lanes or physical barriers in place. And even with that 50% max occupancy, the patrons may not exceed 50 total at any one time. Again, food guidance must be followed. So it's service of food, beverage to your lane. And one particular thing to note is in New York City, there still can be no indoor food or beverage. So that does not change with the bowling alley. Again, you should encourage the use of their own equipment. Make sure it's cleaned and disinfected. And finally, the difference here with the gym is you must screen and test your employees, but you don't have to do so for the patrons, but you can have the option for them to do it. If they want to give you their contact information in case of a contact tracing issue, but you do not have to do it. It's not a requirement. So those are just a few of the updates that have come out recently, Pete. And with that, I'll send it back to you.
Okay, great. Thanks, Sam. And turning now to Katie Anderson. Katie, you have, I know, spoken on this a couple times, but as part of our update today, we're really going to focus on the occupancy guidelines because it appears to be something that folks are just very interested in. Take it away, Katie.
Sure thing. Before jumping fully into the occupancy issues, we're going to touch on a few other things. First, there was a question in the chat about casinos and whether or not casinos will be reopening. And this is just of general interest. Right now, we're looking at a few industries that still aren't open. Amusement parks. You have movie theaters and casinos. Those are, three big things that aren't open. Amusement parks, obviously the window is closing fast. Movie theaters, the governor explicitly said yesterday, concerns about people seated next to each other closely for long periods of time. And casinos, it's that same type of a thing. Casinos have those high touch points. Casinos have people eating. Casinos have people drinking. So I think it's going to be some time before we see casinos. We also haven't seen a real hard concerted push for reopening those things in a, as a lobbyist, I follow a lot of these things, and it really requires to get these to be open. You really need to have advocates that are pushing hard. And that's it's hard to, at this point, push for something that looks like a very risky activity. So I don't know when casinos will open. But turning now to travel advisory updates. Today was a quiet day for the travel advisory. Alaska and Delaware were added. The governor just announced that right before this. So here's our breaking news. So any trips that you had planned to Alaska in the past week when it was off the list, that kind of goes away at this point. And one other thing briefly I want to touch on before going into the occupancy issue is this relates to litigation, and it relates to the reopenings that have been occurring now. This reopening phase 5 that we appear to be in. First, you had 3 cases come out last week that, really just affirmed the governor's position. The NRA sued, saying that it was wrong that gun owners, that gun shops weren't listed as essential. That case was tossed. There was a case saying that the travel restriction, the travel advisory, was unconstitutional. That case was tossed. There was a case brought by racetrack owners saying that it was wrong that fans couldn't be there. That case was tossed. The governor keeps really, the federal courts especially keep affirming the governor's powers in this pandemic. And although the pandemic is easing in New York, it's not easing everywhere else. And that is something that was touched on in this travel restriction case, basically saying that the governor is still responding to an ongoing public health crisis, even if it's better in New York State. So that goes back to the casino issue as well. Whether or not those will be opening, it really depends on how New York does. If New York continues to stay under 1%, there is a good chance that we will see some more things opening by September. But if not, the governor is worried about jeopardizing the reopening of schools. And that is, that's just my take on the whole situation. So turning then to our favorite topic, occupancy issues. I just want to touch on this briefly. Something that, I've been diving really deep into this topic. And this is, trying to figure out your occupancy of your space. That is something that people go to school for. That is something that a building inspector that's their entire career. And in a lot of cases, a building inspector or fire inspector. So, this is a very difficult topic to understand because we have not all gone to school for this at this point. So one thing to really look at with this is I put this is, just a version of this table 10 point, 1004.5. That I put this up there because these are the areas that seem to be the most popular areas for businesses to be looking at. The first thing you want to look at here is in this business area slide part, column, row, you see that it says business areas, it's 150 gross for the occupant load factor, and occupant load factor is how many people you can have per square feet, so how many square feet you need per person. And business areas, it says 150. But then under it says concentrated business use areas. So concentrated business use areas, those are determined by the building inspector. So an office space can have this concentrated business use area designation, and the building inspector can choose an occupant load factor that's lower than 150. So last week I measured my office and we found out it said 0.5. Well, in New York, you round up. So 0.5 occupant load, 0.5 max occupancy goes to 1. Same thing with 0.2. Even a 0.2 would go up to 1 in New York. You round up. One thing to look at here, and this is just a crucial thing, if you are concerned about this occupant load, the maximum occupancy issue, it does apply to essential businesses. Give a call to a local building inspector. They are going to be an invaluable resource for you to use. They will know what occupant load factor applies. They'll know what the function of the space is going to be. So give them a call about your space, about what you're looking at, and where you're going. This will be, very helpful in trying to figure out what your maximum occupancy is, since it is required by New York that we all have to follow this now. So with that, and by we all have to follow this now, let me clarify. You have to follow this if you are following a reopening guidance document. There is likely a reopening guidance document that's applicable to your industry at this point. So if you have to follow a reopening guidance document, you have to follow this occupancy issue. With that, Pete, I will bid you adieu.
Okay, Katie, thank you. Next up, I wanted to just take a couple minutes here to summarize where we are. We've touched on this topic in various webinars over the past 24 weeks, but the litigation issues, and in particular, this is a question that is recurrent, and we continue to get them in the Q&As or for these webinars. So we thought we'd take a minute to try to just unpack it for you and summarize it. When I think about litigation, I really think about it from the perspective of, from whom does the challenge come? And I think category 1 here would be employee claims. And so as we've, touched on in the past, if an employee is claiming a COVID-related exposure, an occupational injury or occupational disease, workers' compensation is generally going to be the exclusive remedy for that employee. The so-called grand bargain of the workers' compensation law, that the uncertainty of tort law recovery would be replaced with the certainty of workers' compensation as the remedy. That doesn't mean that every claim of COVID exposure will result in workers' compensation. There is a causation issue that's going to be present in all these cases. That is, was the disease, in this case, the COVID caused by an exposure at work? And so that's going to be certainly question 1, whether or not there's a causal link between the exposure and the, in this case, the employer. But workers' compensation should generally be the remedy there. That doesn't mean that the only claims that employers might see arising out of COVID would be workers' compensation claims, however. We've touched on this as well, but employers have a duty to provide a safe workplace under the General Duty Clause, the Occupational Safety and Health Act. And so you might see a claim made by an employee that the workplace is unsafe, that the employer is not taking the appropriate precautions. Or you might see a retaliation claim under the Occupational Safety and Health Act that the employee has raised issues and has been subject to retaliation for having raised the issues regardless of whether they have merit or not. You may also see ADA claims, Americans with Disabilities Act claims, claims that employees are entitled to leave under the FFCRA, under the New York paid sick leave statute, et cetera, et cetera. Those sorts of claims are sort of offshoots that due to COVID concerns or due to somebody's health conditions that they're entitled to accommodation or that they're entitled to leave or that they've been retaliated against for having complained. All those sorts of things could come up in this context. So they're not direct injury claims, but they are certainly the kinds of claims that we might see if a COVID situation is mismanaged by the employer. So that's, in my mind, at least category one, the claims that we will get from potentially from employees. Category two are the category I've called compliance issues. And examples here would be the complaints that we've seen filed with the New York State Attorney General's office, for instance, where people are saying that the employer is not operating in compliance with the reopening guidance, or that the employer is not entitled to be open, or that some aspect of the guidance is not being complied with. We've seen a lot, obviously, recently, on bars and restaurants and whether they're operating correctly, whether food is being served, whether the social distancing is being adhered to, whether masks are being worn, et cetera, et cetera. I'm putting those in the category of compliance issues, that somebody is going to complain and say that the employer is not complying or the business is not complying with the applicable operating guidance. We also may see, enforcement actions. And, in this context, again, thinking about bars and restaurants where, their licenses may be pulled if they're not operating in accordance with the applicable guidance. And so category two of claims really is to make sure that you are adhering to the operating rules for your industry. For some groups, some industries, there will be multiple sets of guidance that will apply. For instance, higher education. The higher education guidance talks about each subpart of a higher education institution operating in accordance with the applicable guidance. So to the extent that they have food service needing to comply with the restaurant guidance, et cetera, et cetera. So the challenges there will be to make sure that you understand what guidance applies and to make sure that you are complying with it. The third category, and I think this is the one that we are perhaps seeing, a lot in the sort of the popular media or the, public media, are the third-party exposure claims. Those are the claims that, I came to your facility and I think I may have contracted COVID as a result of being exposed, and you did not exercise due care with respect to preventing the spread of the virus, things that were within your control. These are what we would think of as ordinary negligence claims. And those sorts of claims can be brought by third parties against businesses, against employers, against anybody, to the extent that there's an allegation that the employer did not exercise the appropriate care. Those sorts of things could result in, potential exposure, maybe covered by, insurance policies, sort of general liability or some special policies that a business may have in place. And the usual concerns pertain there as well, that it will be a defense to those sorts of claims, that the employer or the business exercised due care, that they followed sort of the appropriate guidance, the best available guidance, that they were not negligent with respect to the risks associated with COVID exposure and communicable diseases. So With those three categories of claims, just trying to put it in boxes for you, we're then thinking about how do we avoid the claims, or how do we defend those claims to the extent that that we get them. And there are some common things that I think we can do that we've talked about in various contexts, and that people are frankly doing anyway of their own accord. But I think that this advice is still good advice and worth thinking about. Have a plan and follow your plan. That is to say, everybody who's operating under the New York Forward reopening guidance is supposed to have a reopening plan with certain elements in it, and frankly to file those plans or certify that they have those plans with the state, one or the other. And this will be important because to the extent that you have those plans and that you're adhering to them, I think you're likely to have less claims. You're going to have less exposure-related issues because your plans will have the kinds of things in them that prevent those exposures altogether. The cleaning, the social distancing, the mask wearing, the occupancy limits, all these things are designed to reduce the likelihood of exposure, and to the extent there is exposure, to mitigate against the risk of spread. So having that plan and following that plan is going to help you avoid these sorts of claims, and frankly, if you get these claims, to defend them, because you'll be adhering to the standard of care that would be expected. Finally, and I mentioned this at the beginning, but I did want to just sort of emphasize it again, causation is always going to be an issue in every one of these kinds of claims. Given the amount of interactions that everybody has in their daily lives, there's always an opportunity that your exposure could come from multiple sources. So to the extent that somebody says, you caused my COVID disease, you caused me to get sick, or you caused the consequences of that sickness, it'll always be a question of, okay, but what exposure was it that led the person to get the coronavirus? And so that's something that just to keep in the back of everybody's mind in terms of the interactions, that in every case, that is going to be a critical issue. So that's just a summary of where we are on a litigation front. We will continue to present on these issues and subparts of these issues as we go forward. But I wanted to make sure everybody just had that framework to pull it all together. Okay, let's turn now to Jeff Shear. Jeff is going to talk to us a little bit about where we are with the PPP program. We haven't talked about this in a while, and I think it's worth reminding everybody where we are and recalibrating just a little bit. Jeff, please take it away.
Great. Thanks, Pete. It's good to be back on the program. So what I'm going to try and do is give a quick reset in terms of where we are, some recommendations for going forward, what you should be doing in the meantime, because it seems like it's a pretty quiet period right now in the PPP world. So here's where we are. The biggest news that, the biggest change that came out to the PPP, as we all know, was a change from an 8-week covered period to having the option of either an 8-week or a 24-week covered period, with really a third option of having less than 24 weeks for you to cut off your Paycheck Protection Program loan, but still having to comply with the 24-week FTE count, which is something that we've reviewed in the past. So I think that was really the biggest change that we've dealt with, is really the time period. And what we're seeing now is a lot of people starting to look at the forgiveness application, how they can maximize forgiveness, what they should be doing. A lot of uncertainty still. And I will say that if you're feeling a bit uncertain with what's going on in the PPP world, you're not alone. There is quite a bit of uncertainty still. The SBA has updated their FAQs, their frequently asked questions, as recently as August 11th with FAQs on forgiveness matters. I'd be updating you on those, but they weren't entirely substantive. It was a lot of information that we've been sharing and that we already knew. But I think the key there is knowing that guidance is still coming on the forgiveness applications and on the PPP loan program. So I just want to talk a little bit about what you should be doing now. A lot of recipients of PPP loans are thinking about what time period they should be electing to utilize, whether they're 8 weeks or 24 weeks or something in between. And my recommendation to a lot of my clients have been, you know what, just sit tight. Let's see what happens over the course of the next several weeks, how your money is spent, what additional guidance comes out. And based on that information, then I think we can make a decision, because there's no requirement. In fact, there's almost no ability right now to submit forgiveness applications. I think if many of you went to your banks right now to attempt to submit a forgiveness application, your bank would tell you to, sit tight and wait, because a lot of the banks aren't really accepting forgiveness applications at this time because they're not ready to, even though the SBA portal to accept forgiveness applications is open. So I think at this time, it's really important to take a step back, look at ways you're going to maximize your forgiveness either over an 8-week or 24-week period. Review the expenses that you've incurred. I think one thing you should be asking yourself is whether by accepting a 24-week period, you can satisfy the PPP requirements by spending 100% of the money on payroll. And the reason I suggest that to a lot of clients and a lot of borrowers is that if you can spend 100% of your PPP monies on payroll and really not use it on the other permitted expenses, which, as we know, are utilities and mortgage interest and the like, but by spending it 100% on payroll, you're really minimizing the amount of documentation that would have to be provided to the SBA with your forgiveness application. Remember, we've talked in the past about the documentation that has to be maintained for 6 years, the documentation that needs to be provided to the SBA. But if you're able to limit the spending to just payroll, all you're really going to be providing are payroll records, your payroll return, and whatever backup information you have in that regard, and not having to provide copies of leases, copy of utility bills, or copies of anything else that may come up. So really, by limiting your expenses to payroll, it limits your document production, limits the audit review, limits the documentation that you have to retain for the 6 years. So I think that's something to really consider when you're looking at the different time periods. So the next thing that there's a list of things I think people really should be doing right now. The first thing is reviewing your FTE counts and the exceptions to those counts. As we've discussed in the past, there are many exceptions to the FTE count requirements. Remember, just to briefly review, if there's a change in your FTE count from one of the base periods, which is either February to June of last year or January and February of this year, compared against the FTE count during your covered period, if there is a change, it's going to affect your forgiveness amount. But there are exceptions to that. If people have been fired, if people left for cause, if people voluntarily left or retired. One of the big exceptions that we're looking at is a failure to achieve the same level of activity due to state or federal regulations and guidelines. So I think if you do have an FTE difference between the covered period and one of the base periods, I think now is the time to be looking at your FTEs, at your employees that you had, and assessing whether you qualify for any of those exceptions. And I'd prefer, people do it now while you have the time to do it. It may be that you look at the exceptions and realize that maybe you don't have the FTE reduction you think you had, or maybe the FTE reduction is much smaller than you think you have, and you still have the ability to make that up in some cases by December 31 of this year. So I think that's really an important thing to look at, is that FTE reduction and the exceptions to it, and whether you can minimize the FTE reduction quotient. Next thing I think you should be doing is compiling the documentation and information that you need for the application. Again, depending on how what you're going to include in your application, The documentation that you'll have to provide will be either payroll records, utility bills, leases, etc. The next thing that I think is really important that may be overlooked is having a discussion with your accountant or with your CPA, because in a lot of cases, the PPP loan and the date of forgiveness are going to straddle 2 tax years. You're going to receive the loan in 2020. You may not get forgiveness until 2021. That potentially will affect your tax returns. It potentially will affect your financial reporting. So I think that's a conversation that people should be having, again, sooner than later. It's not as if you can change your forgiveness date, but there may be certain strategies to take to get your forgiveness application in prior to the end of the year, if that's possible. But that's definitely something that you should be thinking about. Review your bank covenants. I have a number of clients that are going to fail bank covenants because the PPP loan will not be forgiven before the end of the year. They'll have additional debt on their books, and they know that they're going to fail a bank covenant. And in that case, I would get in touch with your banker right away to see if there's a waiver for this year due to the PPP loan. What may be coming? I'm not entirely sure what may be coming now. There has been a number of proposals in Congress with respect to the PPP program. There may be additional loans. There may be forgiveness relief and in terms of the documentation that's required for loans under $2 million. As we've discussed in the past, the IRS has stated that any expenses that are paid with PPP monies are not deductible. That determination by the IRS has been subject to review and may be questioned. So there are some issues that are still open. I don't have anything definitive, as we know Congress has dealing with some other issues right now and may not be focused on this, and they're on their summer break. So my basic recommendation before I wrap up is wait to apply for forgiveness, even if the banks start accepting applications, unless you are 100% sure that you spent 100% of the money within either the 8-week or either the 8-week or the 24-week period. I would wait to apply for forgiveness until the banks get their feet wet. You don't want to be the test case. You want to wait until all the guidance is out and the banks know what they're doing. And really, there's no rush to apply for forgiveness right at this time. So that's the update. That's where we are. It was great to talk to everybody, and I'll pass it back to Pete.
Thanks, Jeff. A lot of information there. Appreciate that. We're going to turn now to Kate Reed. Kate is going to talk to us a little bit about school reopening. There's an awful lot going on here, so I think this is probably going to be high level, but Kate, take it away.
Sure. So very nice to speak with everybody today. There is a lot going on here. So like Pete said, this is not the in the weeds version. This is the 8-minute version. I'll try to pack in as much as I can. I principally represent public school districts and some of our private school districts here, private schools here at Bond as well. So we've really been getting in the weeds with those clients regarding creating their reopening plans and planning for September. We did do a webinar exclusively for our school clients last week. So if you did miss that webinar and are interested in the in the weeds dive, just let us know and we can get you the slides and materials for that as well. But I want to give just an update of where we are today as we're looking on the horizon towards September 1st, and there's a lot that has been done and a lot that still needs to get done. So in July, we had 2 primary pieces of guidance that came out for schools. There was Department of Health guidance issued that is really our guidepost with respect to health and safety considerations in opening schools. And that was followed shortly thereafter by a guidance document from the New York State Department of Education that was really, really very short and concise, only 146 pages. I'm kidding. But they required certainly very, very detailed provisions, not just around health and safety considerations, but the myriad things that impact schools from curriculum and instruction, special education, obviously health safety facilities, and all of the other issues that come up, as well as employment. So generally speaking, although there are those 2 pieces of guidance, Department of Health and New York State Department of Education, if we're dealing with curriculum and instruction issues, the New York State Education Department guidance controls. If we're dealing with health and safety considerations, then the Department of Health guidance controls. So there's a lot for our schools to be balancing as they look towards reopening. And then if things weren't complicated enough, back on the week before last, the governor issued a press release in which he stated that his expectation was that schools would be more clear about their testing plans. That was promptly followed by, on August 7th, additional supplemental, or August 9th rather, supplemental guidance from the Department of Health that had some additional considerations in it, which I'll provide an overview of in a moment. But essentially back on August 7th, that was the extended deadline for schools to submit their reopening plans. I've been getting a lot of questions from non-school clients around, well, what is permissible in these plans in terms of remote instruction versus in-person instruction? One of the things that's very interesting about that 146-page guidance document from the state is that it really gives schools a lot of local control over what approach they want to use. What is required is that schools include in their plans the flexibility of basically vacillating or oscillating between all three. So there has to be a plan for in-person, there has to be a plan for fully remote, and then also a plan for hybrid, which is essentially a combination of the two. But which plan the district decides to, or the school decides to opt to at the beginning of the year is something that is a matter of local control. So all the plans are in to the New York State Education Department. I have a link on the slide there as well where they've all been inventoried. So you can go to one place and pull your school's plan or the school in which your business is located and see what that particular school is going to be doing with respect to reopening. They were all submitted on, as I said, by on or before August 7th. So we're seeing a variety of approaches that are based on many different considerations. I think the most principal among them are geography, culture, and population size. So we're seeing a tendency on the part of our small rural school districts to really be pushing for fully in-person instruction. These also tend to be school districts in the rural part of our state that have seen a enrollment decline over the last 5 to 10 years. As a result, they tend to be districts that have very few students for larger facility space. Contrast that, however, with our larger urban districts that may have seen population growth or that may have buildings and facilities that are in decline in long-range facilities planning that's been delayed. As a result, they have many, many students that they have to accommodate in their physical plant, and they may not be able to do so within all of the health and safety parameters in that 146-page document. So, by example, it was recently publicized that Rochester City School District will be fully remote for at least the first, I believe it's 2 months of the school year. Buffalo City Schools made a similar announcement about a week and a half ago, although I hear that they may be backtracking a little bit on that and looking to transition to in-person a little bit sooner. I'm aware also of some other urban districts that likewise have made that very difficult decision. Question you may all have is, who's making that decision? What is it based on? You know, is it in terms of remote versus in-person? Well, the guidance documents, both the DOH guidance and the SED guidance, require schools to solicit considerable feedback from stakeholders, which is their communities, their parents, and their staff regarding preferences and feelings about reopening. So what happened in a lot of our urban districts around the state is then when that stakeholder feedback was solicited, parents expressed that they were very reluctant to send their kids back to school. And in those districts, we're seeing more of a push towards at least opening the school year remotely. Next slide, please. Okay, so in terms of the supplemental guidance that I referenced that just came out last Monday, there are some requirements in that guidance that have raised some concerns and questions regarding particularly testing and community outreach. So as I mentioned before, there is a requirement as referenced by the governor in his press release that there be stakeholder communication and outreach. So between August 7th and August 21st, schools are required to conduct at least 3 community town halls and 1 employee only town hall in order to roll out their reopening plans and get feedback on those plans from their communities. The majority of schools that I work with at least are doing that via some kind of remote means. whether a Zoom town hall or some other technology where people can submit their concerns either in real time, synchronously, or in advance or after the town hall. Testing was one of the issues that raised additional concerns as well. The governor obviously made some statements which may have, all of you may recall back last Friday, where he stated that schools better be prepared to say how and how often they're going to be conducting testing. The supplemental guidance from the DOH that came out was a little bit more reserved than that. What it stated was that that schools need to be prepared to explain how, where, who, and under what circumstances testing will be provided. Now, it's important to note that under existing provisions of the public health law, which have not been overruled by any executive order or by our legislature, it's actually illegal for schools to conduct testing of minors, any medical testing of minors, without parent consent. Also, in that large guidance document that I already referenced from the State Education Department, there was a strong recommendation from the Department of Health that schools not engage in testing themselves. They're not certified to do that. They would have to get special dispensation from the Department of Health to do so. And the CDC recommendations are that schools connect their students and families to resources in the community where they can be tested, but not actually conduct the testing themselves. The supplemental DOH guidance seems to reaffirm that. So it really recommended more in the nature of, having a district explain what it's going to do to facilitate testing, but not necessarily to do the testing itself. So what I have seen in that, and the trend that you'll probably see in your districts and the districts where your businesses are located, is that the reopening plans of most of our schools have collaboration provisions, so that the districts will collaborate with the local Department of Health with local testing facilities in order to connect families who have a need for testing to those resources. So in addition, the last part of the supplemental guidance was that districts needed to update their reopening plans to specifically identify the protocols that they'll use for symptomatic individuals and positive cases. This has been also a little bit of a struggle in the sense that the DOH guidance is in some sense a little inconsistent with the guidance from the State Education Department. So there's a requirement of more specific provisions regarding that, how students and staff will be tested and how they will be referred for testing, and then the roles that staff will perform and who will be responsible for connecting folks to testing. So that was the big takeaway points from the recent guidance. I think we will be seeing over the next couple of weeks, as we get closer to school reopening, more districts that were originally gung-ho about being 100% in person and on the ground will be informing their populations that they will be going to remote, at least for the first part of the school year, just because the facilities management considerations involved in reopening are proving to be very challenging. Also, what is proving to be challenging is the reluctance on the part of a lot of families to send their kids back to school. That, of course, for employers, both school employers, but also, of course, every other employer in the state, is presenting unique and difficult accommodation considerations. And we've presented at length on the issues regarding intermittent leave and the uncertainty in the law with respect to that issue, but that's going to come to the forefront if we have districts that are, as many of them will be doing, being in person for certain days during the week and then remote for other days during the week. How employers, both school employers and other employers, will manage those concerns will be, will be increasingly complicated. Next slide, please. So as I said, there's teacher accommodation issues for the individual districts, but there's also childcare consideration issues. To what extent, if you are an employer that is not a school, that you will nonetheless have to deal with these school issues because your employees may have children who are in schools and who are on these varied schedules. There's transportation concerns. So a lot of schools contract with outside agencies to provide transportation. Others do it in-house, but either case, there's unique health and safety considerations involved when you pack children into buses and transporting them, as well as, of course, the social distancing and facilities use considerations. And then finally, there's the liability issues. In schools, many of those are the same as what Pete already outlined. We've seen a push on the part of the National Superintendents Association, which is an advocacy group for school administrators around the country, to actually seek a waiver from Congress that would apply to all schools in the nation, to provide some kind of exemption from COVID-19 related personal injury liability. So far, that's not picking up any steam. I think we can all speculate about whether it will or won't, but the reality is right here, there are liability issues that are here to stay. There's workers' compensation issues, as Pete mentioned. There's personal injury considerations. There's certainly, ADA and other personnel-related issues. And risk tolerance of communities is turning out to be one of the biggest issues that's driving a lot of this planning process. There are districts where fully 50 or 60% of the population of their parents is saying, I'm not comfortable sending my child to school. That is obviously a very different situation than a district that is dealing with a parent population that is eager to get all of their kids back to school immediately. So those risk tolerances vary from community to community, and that's why you're going to see a ton of variability in the plans around the state. So I'll hand it back to Pete.
Okay, thanks. I mean, the real challenge, or some of the challenges here, are associated with the uncertainty, obviously. And although what you have presented is very clear and brings as much certainty as possible, there really isn't much certainty at all in terms of what the individual district plans are going to look like, when they may pivot to different options, and frankly, therefore, what the parents are going to be able to do by way of their expectations. A lot of employers are waiting to see what happens with their school districts, and if they draw employees from multiple school districts, they may have parents who are employees who have availability that's all around the lot.
Yeah, that is absolutely true, Pete. I think I think that it's going to be a very murky landscape for employers in all sectors as we move forward, and hopefully we'll get clarity either from the DOL or the courts regarding this intermittent leave issue, because I think that's what's on everybody's mind. And the extent to which employers, even those that want to be understanding and to provide as much accommodation as possible, will simply not have it will not be reasonable and feasible to, as you said, accommodate multiple school district schedules that are represented in their employee population. That's going to be very challenging. And you're correct that what the state has essentially said is that because you are required to prepare plans for remote, in-person, and hybrid, that districts will have the flexibility to oscillate between those options, and that won't necessarily require a statewide school closure order in the way that it had required that kind of order back in the spring. So we may be in a situation where not all schools are closed due to COVID, but we have certain schools that are closed or offering different kinds of instruction, and districts have to pivot, and as do the employers of their parents.
I guess that it just tells me that the premium is on flexibility. We're all going to have to be flexible and react. One other quick update. There were some questions on the payroll tax executive order, and that would go into effect September 1 and go through December 31. There are a number of questions about how we would interpret that, and there's indication in there that the Treasury Department would be issuing regulations. So we will get you an update on what is known next week, but stay tuned on that. So thank you all for being with us today and every week, and we'll talk to you next week. Please stay safe.